I thank the gentleman. We now go to the gentleman from Maryland, Mr. Ivey, for 5 minutes.
Thank you, Mr. Chairman. Good morning to the panel. Ambassador Shea in particular, good to see you again.
Hey, Glenn, how are you? May I call you Glenn?
You may.
All right.
I'm going to call you Ambassador, though. So. Let me ask this question. Let's start with Mr. Gresser. In your testimony, you talk about China foregoing the use of the waiver. And give me your thoughts as to why that might be. Why do you think that they didn't use the waiver in this instance?
It's not easy for me to enter the mind of Chinese negotiators and their overseers in Beijing, but I think they may have felt, one, that they were very committed to their own vaccine, Sinovac. They have put a lot of money and a lot of kind of publicity into it and may not have been that interested in the US and European vaccines. Another is that they may well have seen that the scale of vaccine production in the West was ramping up very quickly and that there would not be or would not likely be a worldwide shortage, that they would need to see their own need to use a waiver. It may also be that they have their own plans to go into the US technology waiver or not. All those things I think are possible, and there may be more than one of them at work.
And going to Mr. Saddam's point about whether there was direct harm or not, what's your sense with respect to that?
I think, I don't want to characterize Mr. Saddam, but I think he agreed that there was not direct harm to research. It has always been the case that within the WTO's TRIPS agreement, there are flexibilities, and ever since 2001, there has been an explicit statement that governments have the right to take action in the event of public health emergencies. That is understood. It has not been frequently used. I think most people will say that the COVID-19 pandemic was such an emergency. And I think they will look at the fact that governments have not actually used this and probably conclude, yes, there is some risk, there may be another such event in the future, but that governments are pretty careful about how they do it and they don't recklessly and willy-nilly take intellectual property. So I think on balance, you can look at this experience and say this was fairly reasonable. They took a prudential decision in an emergency, found it wasn't necessary to use, and no one has used it. So I think that should give some confidence to R&D investors.
Professor Bush, in your testimony just a moment ago, you said exceptions should be narrowly construed and rarely used. Is it your sense, I would assume that you'd think COVID would be within the range of the narrow exception scenario?
I definitely agree with Mr. Gresser that there was a lot that was unique about that dire moment in COVID in the early goings. The question that I have, though, is, let's just take that as given. Why are compulsory licenses the answer? We all agree that we want access to medicines. We all agree that we would like cheaper drugs. But compulsory licensing is a very particular mechanism. There is absolutely no evidence that this particular mechanism is the solution to that problem. And that's where things get complicated. So on its face, I totally agree. COVID was very unique in many exceptional ways. But that doesn't mean that what we do is we run with this very cogent narrative and ignore all the factors that are weighing on access to medicines, including the fact, mind you, that there are 20 developing countries with no WTO legal limit on their tariffs on pharmaceutical drugs. That is simply unacceptable. And there are quick fixes for this, including zeroing out those tariffs in these same extraordinary times and zeroing out the taxes in these same extraordinary times. There are other alternatives. This idea of a compulsory license is not a unique equilibrium.
Let me ask you about I think you gave a valuation in response to Congressman Massey's question of 5% to 7%.
Yes.
And I don't mean to characterize your testimony, but I sensed there was a sense of regret with the numbers that you gave. I assume you think that was too low?
That's what Indian courts have been issuing, 5 to 7% royalty fees on compulsory licensing. I would imagine that the technologies are sufficiently heterogeneous that it's hard to pinpoint an exact number that would work across the board. But I can tell you that there has been no love for these numbers on the part of those who have been essentially expropriated.
I see my time has expired, but I look forward to another round. I appreciate your testimony.
I thank the gentleman. In that last question, I'm sure we're going to